Hey guys, and welcome back. Today's video is going to be a little bit different. Instead of dealing with substantive law on temporary injunction, we will be dealing with the procedural aspect of writing an order for temporary injunction. In all states, you get questions in Judicial Services Exam where you have to write an order. So you have to pretend to be the judge and pass an order. And temporary injunction is one of those topics which is very commonly asked. But even if it's not temporary injunction, you have to understand how to write an order for any subject, for any topic. So today we will show you how to do that. Now here's why it's important. In competitive exams, everybody studies from the same books and knows the same case laws. For example, in CPC, if there's a question on temporary injunction, most of the candidates would have studied from the same book. Most of them would have studied from Takwani for CPC. And they would know the same case laws, they would know the same interpretation because everybody studies from the same book. So the knowledge pool of law is very stagnant, doesn't change very often. Everybody knows the same stuff. But not a lot of people know how to write polished answers like you were a judge. So this is a creative strategy to differentiate yourself from others, to show that you're polished, that you're better, to get a leg up, to get some brownie points. So it's important to think of new and novel ways to differentiate yourself from thousands of other candidates. Writing orders with correct format is one such way. And whatever strategy you can find which will give you a little bit of advantage over others, it's very important in competitive exams because in competitive exams, people don't get through by 1 or 2 marks. In competitive exams, with 1 or 2 marks, you can be above or below the cutoff. So the difference would be that you prepare for 2 years, but then 1 or 2 marks can keep you below the cutoff. So any advantage you can get in competitive exams is fair game. Let's say, for example, let's take a question on temporary injunction and then let's see how one would write order on that. So in this example, let's assume that a person files a suit for declaration of title and along with it files an application for ex parte temporary injunction requesting the court to restrain the defendant from selling the suit property. He alleges that if the defendant sells the suit property while the suit goes on, then the suit will become futile. There will be no point to the suit because he will get rid of the suit property. So please issue a temporary injunction ex parte. This application is filed along with the suit. Even though we will not be discussing the law on temporary injunction today, you should have a basic idea where the law on temporary injunction is given. So law on temporary injunction is given under Order 39 of the Civil Procedure Code and it can be read with section 94 clause C and clause E and also with section 151 of the CPC. We'll make a separate video on the substantive provision of law, but if you have a basic idea, you understand that temporary injunction basically serves the purpose of passing a temporary order while the suit is going on, restraining the defendant from doing something, for example, in this case, from selling the property. So it would injunct the defendant from selling the property. And temporary injunction law basically looks for 3 factors, which is a prima facie case, a balance of convenience, whose favor is it in, plaintiff or defendant, and irreparable loss. So if the order is not passed, will it cause irreparable loss to the plaintiff? And the landmark case on it is Gujarat Bottling Company versus Coca-Cola Company. There are more cases. We can discuss it in the substantive law video, but for today, you understand the basic law on temporary injunction. And today we will be discussing how to write orders. So this is just an example we've taken. That this question is on temporary injunction. This is the law. Now let's see how will you write the order in this case. First of all, you'll have to write the title. I will not go into very detail for the title over here because we have a 40-minute video discussing everything and how to write the title. So after writing the title in the court, you will write application under Order 39, Rule 1 and 2, read with Section 151 CPC in suit for declaration. The law point is clearly mentioned. You write one line, what is this application that you're deciding today? What is the law regarding it? It is filed in a suit. And then you will write present Shri ABC for plaintiff. Now understand that this application is coming up for hearing on the very first day. This is the first hearing. So over here, notices have not been issued to the defendant. This is the plaintiff who's filed a suit along with an application for temporary injunction. So right now, notice has not been issued to the defendant. So there is nobody present for defendant and only Shri ABC is present for the plaintiff. All these small things make a lot of difference. They show that you understand the formalities, the regularities of court, and how court procedure works. So once you've given the heading, the title, the application under what, present, so and so for plaintiff, and this is the first hearing. So then you write suit received by entrustment, report of the reader seen, and suit to be registered. So the first line, because this is suit and application and this is the first time it is being heard. So the first line will be whether or not suit is registered. Only once suit is registered, then you can hear temporary injunction, right? So the suit has to be registered. So first line is that. This is what's written in court orders by judges, and if you've attended a court hearing or you've practiced for a while, you understand this. If not, you can learn this line and you can write it in the exam. It will show that you understand court procedure. After that, we move on to the injunction now that the suit has been registered. So you write, along with the suit, plaintiff has moved an application for temporary injunction under Order 39, Rule 1 and 2, read with Section 151. In this case, after hearing the learned counsel for plaintiff, I am of the considered view that it is a fit case for granting ex parte injunction, and if it is not granted, the very purpose of the suit might get frustrated. So the defendant is restrained from alienating the property mentioned in the application up till the date so and so. So whatever date of the year 2017 or 2018, whenever you're giving the exam. Then you write, let notice of the suit as well as application be served on the defendant. So once the suit is registered and you have given a decision on the temporary injunction. Now understand, very important, that this is not the final order on temporary injunction. This is the very first hearing. Defendant is not present here. This is not on merits. This is an ex parte temporary injunction on which you've said that fine, go ahead with it. If the defendant gets rid of the property, the suit will become futile. So fine, defendant is restrained. After this, in the second hearing, then the notice will go to the defendant. Then the defendant will appear. The defendant will file his papers. The defendant will file the reply. And then in the third, fourth, and later hearings, you'll find the final order where you've heard both the parties. So this is the very first hearing in which defendant is not present, only plaintiff is applied. So hence you have written, let notice of the suit be served on the defendant. And after that, you say that plaintiff is directed to comply with the mandatory process given in Order 39, Rule 3. Once you read Order 39, Rule 3, you understand that it provides certain mandatory things that have to be done. So you write, plaintiff is directed to comply with Order 39, Rule 3 in 24 hours, failing which ex parte injunction shall stand vacated. Signed and stamped. So this is a very basic, rudimentary order on the very first hearing in which there are no merits involved per se. Both parties' sides have not been heard in this. This is a very basic order, and I want to start with this very basic order for you so you can understand and get a little bit of idea, a little bit of taste of what order writing is like. This is how you have to write the order during the exam. If you get a question which has all the facts and then it says pass an order on temporary injunction or pass a judgment, you have to apply mind on the law, you have to apply mind on cases, application, interpretation. That's the basic, that's the substance, that's where you will get the marks. But if you write it in the correct format, in a more polished way, it will give you a significant advantage over others because it shows that you are a little bit ahead, that if you are selected, they will have to apply lesser energy in training you because you already understand these aspects. So this is why we are showing you this order today, because it's easy step to try and imagine order writing. This is how you put yourself in the shoes of a judge and you write orders and you write judgments in Judicial Services Exam. So you don't just have to know the law and interpretation, but you also need to have a fair idea of the procedural aspect in order writing formats to score some brownie points, to distinguish yourself from others who know the same case laws, who have read the same takwani, who are going to give the same interpretation. The format we discussed today you won't find in books or guides. There is no book which will give you answer writing formats or order writing, judgment writing formats. Only judges who write these kind of orders every day, or advocates who practice or who have gotten these kind of orders every day would know these formats. This kind of practical hands-on knowledge can give you a leg up, and you should take it with both hands. If you want more order writing formats, answer writing formats, you should know that we have a 40-minute huge magnum opus video on it, which is a part of our premium content. It includes general answer writing tips. It will give you judgment writing format for civil judgments like CPC, etc. It will give you judgment writing format for criminal judgment. For example, if you have to write a judgment on murder, which is very commonly asked, it'll give you the format for that. It'll give you civil order writing format like the order writing format we discussed today. So judgment writing is different from order writing. Orders are during the course of the trial and judgments are the final end word. So order writing formats, judgment writing formats, different thing. And also that video discusses charge framing format, which is very important because charge framing is a question which is being asked increasingly for Judicial Services Exam. So charge framing format is something that you won't find. That video has it if you want that. In that video, we also discuss application-based answer formats if you are in a time crunch or if you're short of time and you don't have the time to write the entire format, then what do you do? And also how to write theoretical answers. So that's the video. And if you don't know about it, we also uploaded a trailer for that video 2 videos ago. But I will link the trailer on your screen. And if you want the full video after watching the trailer, I will leave the link to our online store where you can get the full video in the description box. So watch the trailer, and then if you want to get the whole video, then you can go to our online store and you can get it over there. I'll leave the link to the online store in the description box. So our advice is that you should follow order writing formats. It will distinguish you from others. Practice these order writing formats along with your knowledge of law. So that's our advice for you. If you have any more questions, feel free to email us, leave it in the comments, and make sure you hit subscribe so you get notified of new videos.